p.m. And we are live every Friday on Facebook Live, 6 o'clock in the evening. You've got a question, our attorneys have the answer. So let's talk law with attorney Daryl O'Neill on the SVP TV network.
Welcome to Talking Law with Daryl O'Neill. I'm your host. I got my main man, Jerome.
What's up, Daryl O'Neill?
Man. Got a new show for you today. We're going to talk about some probate law.
Oh, yeah.
First, Jerome, I need to get, if you have Facebook, YouTube, Facebook Live, YouTube Live, Apple TV, a Fire Stick, Roku,
Yeah.
or the SVP TV network app. At some point, Angel gonna put up the phone, and you can call in and ask questions. Annoyingly, y'all never call in. And I appreciate y'all not calling in, because that means you're gonna call me in my office. I'm gonna charge you a consultation fee. So, that's the benefit, but that's okay. All right, so we got to give our shout outs, Jerome. So we give shout outs to California. We're gonna travel on down. Shout outs to Little Rock, Arkansas. Shout outs to West Memphis, Arkansas. Shout outs to Memphis. Shout out to Mississippi. Shout out to my family. Shout out to Jerome's family.
Thank you, Daryl.
Shout out to the great state of Missouri.
And also, Daryl, heads up and kudos to Miss Debbie. They're moving down in Jackson,
Yes.
Mississippi.
Yeah, and
Whoa.
and the good thing is, we're gonna have Talking Law with Daryl O'Neill in Jackson, Mississippi. So we're gonna have to start giving out shout outs to Jackson.
You go, Miss Debbie.
Yes. So, Jerome, probate, we talk about this a lot,
Yes.
but there's a real reason why we talk about it. Because the question is, and I deal with this a lot, is that the wishes of someone after their death is not happening.
Because there is only one document that speaks for a person who's no longer here, and that document is originated in the probate court. So the question becomes, how do you access probate court, which is how we get to tonight's show. A lot of things you can do to try to avoid going there, but if you fail to plan, then you plan to fail, and you wind up where? In probate court.
Yeah. I mean, the default is always going to be probate court.
Yes.
And I say this a lot, and I'm going to say it again.
Okay.
The worst lawyer in the world, the absolute worst lawyer that we have in this world is Google. That's the worst lawyer we have in the world.
Oh, yeah.
Because everybody wants to go to Google and believe that they can learn the law through Google.
The worst lawyer in the world is Google, out of context.
Now, I say Google
because I use Google.
Well, we all use Google.
But we use Google because we know when we get the information from Google, we know what to do with it. But a novice person going to Google can wind up in a lot of trouble just by surface learning.
But the second worst lawyer I'm learning in the world is LegalZoom. That's the second worst lawyer I'm learning.
Okay.
And there's some other, calllaw.com or whatever. There's all these, form shopping things. And let me tell you the reason why, Jerome, I say that these are worse lawyers. Tennessee law on a will is specific.
No doubt about it there.
And if you miss a step, no matter how much time you put in it, you have an invalid document.
Yes.
I tell people all the time, Jerome, a holographic will, if you don't get a lawyer to do it, is probably the safest will.
But it's so easy to screw that up too there by trying to make it more to make it more solid than what it is in your mind. You might try to put a stamp on it for a date stamp, or you might try to get someone to notarize it. Any of those additional steps will, in fact,
Invalidate.
discount
Yeah.
everything.
Not
that you
discount,
did.
invalidate.
Yeah, invalidate.
Yeah,
And,
'cause-
so what does invalidate mean? It means that you will not be able to go forward with that document.
Or you won't be able to do, the person who wrote it, their wishes will not be
Okay.
accomplished. I mean, that's really what I mean when I say invalidate.
I hear you. Yeah.
So, let's talk about this.
Okay.
A holographic will is a $10 word for saying a handwritten document.
Right.
And the great thing about a holographic will, let me just tell you how simple this is. A holographic will, all it has to have is, you have to have it in the person's handwriting, or or somebody's handwriting. It should be the person who is getting the grantor. It should be in their handwriting.
I see where you're going, because you're right, but that signature has to be
The grantor.
the testator,
The testator.
or the testatress.
Yeah, and that's and I haven't really delved into the point of whether or not somebody else can write it and you can sign it.
Yeah.
I don't know that specific.
Well, I don't see why that would be an issue.
Yeah.
Because, and then someone has to verify that I knew Miss Jones, 5, 6, 7, 8, 10 years, or one of the children or a neighbor can say, and I know this to be her signature. I think that's the only thing that would be required, wouldn't be there?
I don't know the answer to that, Jerome. I mean, the way I've always explained to people of doing a holographic will is I tell them that they need to write it.
Yes. Yeah.
And in fact, I've done holographic wills for people. Because what happens is I have friends and clients they're in the hospital and they have failed to do a will prior to being in the hospital.
Okay.
And then now they have said that I need to take care of my affairs because I'm not certain I'm going to die, but I'm not in a good state right now.
I don't know if I would do that or not.
Oh, I've done it numerous times. And here's what I do.
Well, why don't you just go and do a full will by having 2 witnesses with you?
Because I have to bring people.
Oh, okay.
And I don't have, you got to take your.
In other words, the more resources you have to add,
yeah.
it takes it out of the.
It takes it out. Yeah.
I guess.
And the hospital will not provide.
No.
They will not provide anybody.
Well, they cannot, because that's one of the things that's a prohibition, is using healthcare workers
Yeah.
to witness a will.
Yeah. So they can't do any of that stuff.
That's true.
So what I always do is I'll take the will. I'll take a piece of paper, and then I'll ask the person, so what do you want to do here?
That's interesting.
And then they'll say, so and so, so and so, so and so, so and so. And then what I'll do is I say, okay, well, let me start this off for you. I will write, that my name is so and so, so on. I'm above the age of so and so, so on. I'm of sound mind, and this is my last will and testament.
Oh, I like that.
So then I have them. So I tell them that, and then I may write it out or type it out or whatever, and then I have them write that on their piece of paper.
Oh.
And then I tell them to say, okay, what do you want to do here? And then they tell you, I want to do 1, 2, 3, 4, 5, and then I write it out on my piece of paper. And then I tell them, okay, now on your paper, go ahead and write those things out that you want to happen.
That's interesting.
And then I'll ask them, okay, do you want somebody to administrate it for you, or because that's not required in a holographic will.
Right.
But I'll ask them, do you want somebody, you want an executor or executrix, who do you want to oversee it? Because what this is and I'm not trying to be disrespectful when I say that. This is a poor man's will.
Right.
Right. And so it's kind of like a poor man copyright, a poor man everything.
Yeah.
You can do this yourself. You just have to be able to prove that it was what you wanted and what you did.
That's interesting, because what I would normally do if someone was hospital confined, I would go to the hospital. Can't use the hospital workers, but I can always go to the surrounding rooms, and ask them if they wouldn't mind coming to witness this document for
yeah.
this patient. Because normally the way things are now, it's no private rooms anymore. You usually have at least 2 people in the room. So the visitors are there with this other family, and maybe you can because they've gone to know each other now.
Yeah.
Because they've been confined for a while.
Yeah, I mean, that's a way. Again, I'm always simplistic about it. And, I'm always extremely simplistic about it.
Okay.
And if the client that I'm going to help Every time I've ever done it for a client, they've been in a room by themselves.
Okay.
But if the client was in a room with somebody else, you know, there's times when both people are not going to be in a room at the same
That's
time
right.
for whatever reason.
That's right. Because it is a private event.
It is.
Yeah.
And so what
That's
I'll
right.
do is I'll learn, my client will tell me when that person is going to be
yeah,
out
that's
for
good.
whatever, and then I'll come in and do it.
That's good.
Or I'll be visiting them, and then they'll say, well, you know, you hang around a little longer, they're going to be
That's
gone,
good.
you know,
Yeah, because they go for tests. or
tests and
something.
all
Yeah.
that. And then, you
That's
know, that's
good.
enough time for me to do what I do.
Yeah, that's good.
And then I tell them when they're all done, I tell them, okay, you good with this? And then they say yes, and I say, well, go ahead and sign it. And then that's a valid will.
And then do you take it, or
I
you
do.
just leave it with them?
I take it.
Okay, I got
Usually the client wants me to take it.
Okay.
So I take it, and then I fold it up, and I hang on to it for
Okay,
them.
okay.
You know, and, you know, now, and that's the cheapest way. And they'll tell people, you know, and then they'll tell them, you know, hey, you know, I did a will, my lawyer's got it.
you. Yeah, okay.
And then that holographic will is kind of what you, and usually what you have to do is you can have two people that's going to testify that they recognize, and that's the reason why I don't know if somebody else can write, that they recognize the handwriting on this will, and it happens to be the handwriting of the testator. And then I'll ask him, do you recognize his signature? And it happens to be the signature of the testator. And usually you don't want that to be, and most of the court's not going to normally allow it to be, a person that's taking from that document.
That's true. And you know, and what you actually did was it sounded to me, with my years of experience in watching a lawyer present a will to the court, that's exactly how you would do it. Your Honor, I have a witness with me that I want to, I'm prepared to open a probate estate.
All right.
Mr. O'Neill, you have a witness? I do, Your Honor. And then the witnesses go take the stand, and that's how you would do it. State your name and address for the record. You're a resident of the state of Tennessee for more than 6 months. Is that proper?
Yeah.
Okay.
So you walk through the
you
steps,
walk through
yeah.
the steps, and you say, I'm going to pass forward a document for your identification. Is that how you would do it?
I do.
Yeah.
And then I'll say, you know, do you know so-and-so, so-and-so? And they say yes, and I say, I just showed you a document. Do you know their handwriting?
Right.
And then they say, well, yeah. Is that so-and-so, so-and-so's handwriting? And
right.
they say yes. I say, is that so-and-so, so-and-so's signature? And they say yes. Okay. And then, and I say, how long have you known? Because that's not really required. It's
Right.
just, the requirement is that they know this person's handwriting
Right.
and know their signature.
And among their books, papers, documents, and whatever, you found a paper writing that's purporting to be their last will and testament. Yeah, and so that's why Google won't do it, because you don't understand how to present it later on. There's certain rules, and I tell people all the time too, there. Trying to operate in an area where you have no familiarity is a landmine.
It's a death trap waiting to happen.
Right.
And so then when you do that, so that holographic will, you know, because there was a time, Jerome, that, you know, my grandparents, what they did is, my grandparents and their peers, they would write stuff and then they would put it in the Bible. And the court would allow a Bible, you know, to be, you could actually use a page off the Bible,
Right.
in the Bible book, to be somebody's last will and testament.
I thought you were going to say that they signed it with the X. How many times have you done that?
I have not seen an X in a long time.
I have actually introduced documents in court where the person did not know how to read or write, but they could make their X. And
Yeah.
so I don't know, that's probably out of fashion maybe by now, but when I first started practicing, it was common for some people, some elderly people, to have never ever learned how to read or write.
Yeah, I think since I've been practicing, I've only encountered one person that could not read, or could not read. It's not they could not read; they could not read well.
Yeah, okay.
And that person was actually a young person.
Oh my God, Darren.
Yeah, that person was, I don't know, 20-something years
Oh
old.
my God.
And I don't know what happened or why they were there.
Well, they said Fantasia was unable to read for a while until she started to become more into her music and stuff, and she decided to, get rid of that handicap that she was operating under.
Well, look, I can understand you at some point not being able to read in life. But I don't understand how you go through life forever without learning how to read. And what I mean by that is, there's children that don't know how to read. But as they get older, they learn. Now, are they proficient? Because this is what they say. And I'm talking about the flipping, the people who are always giving their opinions, right?
The talking heads.
The talking heads.
Okay.
Us.
Yeah.
They say it's the average person the average person in the United States reads on about a 6th grade level. And believe it or not, most of the magazines, most of the books that you're reading, with the exception of some of the better books, are written on about a 7th, 8th grade level.
Oh my goodness.
Yeah, and so I mean, because obviously you want to bring more people into the fold, and I have never been able to do it, but I know people that read lines by reading 1 or 2 words in the line and moving on. They can tell you the gist of the sentence, and that's trained.
Right.
They don't read the entire sentence or the entire paragraph. They read, and they have learned in their mind how to excerpts, portions to get the contents.
Right.
Now, I can do that on documents
Right.
that I'm prepping for. If you give me a document in court, I'm not going to read the entire document right then.
Of course not.
But I can look at it, and my mind would allow the words or allow the portions that I need to punish you with to jump out.
But Darryl, we got this same issue coming up again this year, where they're getting ready to hold back a whole group of 3rd graders again for not being proficient enough to go to the next grade.
Yeah.
And so whenever I am around children, grandchildren, the neighbor's children, anybody's child, I want to hear them read, because I tell my church members the same way, the same thing, that when these children are in Sunday school classes, we should have them reading so we can pick up on the fact that a child is not advancing. Because there are always cues to it. And an education is the one. Education is worth $1 million there. But people need to know that if you ever, and I love Sister Act 1 or 2 said, if you want to go somewhere, if you want to be somebody, then use your head or something to that effect, because an education will break down barriers that no one can ever hold you back with.
So when we, back into that, even that holographic wheel can be done that way. And so, Ladrone, when you say that, what you just said, that a person, so if a person can't read or can't write and they want a holographic wheel, I guess your argument would be that somebody could write it for them, and then they can make their mark.
And Dad, we always do that too.
Yeah.
Well, I'm not saying we always do, but many times, most documents would say that I have read or had read to me. How many documents have you seen like that?
Most of the ones now, unfortunately, Jerome, that I see is I have read.
Okay.
And it says, and it's, it says I have read and I understand the contents, and I had the opportunity to hire a lawyer and on this. That's
well,
what
there's
most
some
of the
documents that because during the pandemic, we were given permission. We didn't have to have wet signatures on every document.
Oh, yeah,
You
you,
know-
you still
you know
don't have
where I'm
wet
going?
signature. Yeah, you don't have the wet
You know where I'm going?
Yeah.
So I'm saying that so many times the person didn't actually read the document. The document was read to them, and then the attorney had permission to sign the document on their behalf.
Yeah, I don't know, because I think declarations of clients and declarations and affidavits, they still have to have wet signatures.
Okay.
But, you know, pleadings, motions, memos, things that notices, things of that nature that lawyers file are not, you know, you can use what they call an electronic signature.
That's right.
and
That's
it's
what
acceptable.
I'm talking about, yeah.
But you can't, you're not supposed to be able to do that with declarations, affidavits. And I guess a lawyer, maybe can do it with a declaration.
Even
because-
with a complaint, right? You can do it with a complaint.
You can do it with a
right?
complaint now.
Right.
Yeah.
Okay.
Because, I mean, I think, so the rule used to be in Chancery Court and Circuit Court, they've changed it now, but the rule used to be that you had to have a wet signature.
Right, exactly.
And so, okay, and I said to the clerk and master, the old clerk and master, that's stupid. I said, because if we're gonna do electronic filing, right?
Right, exactly.
Then what you're saying to us is, we need to prepare it, print it, sign it.
That's exactly right.
Scan it back up.
That's exactly
and then
right.
file it.
That's exactly
And it
right.
said that-
Because you gotta have this wet signature.
It defeats the purpose of being electronic.
True.
And, you know, then Chancery Court originally went to electronic signatures, then they backed off of it, and then they back on everybody's. Now you can do electronic signatures throughout.
In all the courts.
Chancery, probate, or circuit court.
And bankruptcy.
Yeah, see, well, bankruptcy, federal court.
Yeah.
And federal courts had electronic signatures
I got
since
you.
2004.
I got you.
No, 5, I think it was.
Okay.
So, because they've been electronic the longest.
Okay.
The federal court was one of the first electronic systems, and bankruptcy court went pretty fast.
Yes,
And it was
yes.
about 2005 or so.
Yeah, we've been doing it a long time.
Yeah.
Yeah.
Because I took my electronic class through bankruptcy court.
Is that right?
Oh, yeah.
Okay.
So it had to be 4, because in 5, didn't it?
2005 is when the law changed.
So I stopped in 5.
Right.
So it had to be in 4.
Before then,
Yeah.
okay.
So it was in 3 or 4. Yeah.
Okay.
Wow, that's crazy.
That is
man.
crazy, isn't it?
Yeah. And and I gave the courts a hard time about it, because I told some of those, when we used to go to bankruptcy court down there, it had an office, it seemed like it was thousands of people in the bankruptcy office. And they were like, "Oh man, this electronic thing is great, man. You know, I don't have as much to do." I said, "Yo, you're not gonna be here." I said that to a lady once. I said, "You're not gonna be here." And she, "What are you talking about?" I said, "Electronic is gonna put you out of business." Oh no!
And now when you go in there now, it's not a thousand.
It's 2 people. No, it's like Walmart. You go to Walmart, they got 2 registers open,
Right.
2 real people, and 15, self-pay.
Right.
So, but the whole point of this thing we're talking about with the probate on this will is, you have to have a way to have your voice heard.
That's right.
And that first way, the simple way, is that holographic will. And you don't need any lawyers if you can't afford it. You can, like I said, you can do it yourself. And it's really simple.
But even though it's really simple, you still got to have a lawyer to present it to the court.
At some point.
Yeah.
But you don't need a lawyer.
Not to prepare the
and,
document.
and I don't want to sound flippant. Dead person don't need the lawyer.
Right.
Their heirs may need them, but they don't need them.
Right.
Again, they're doing what they need to do. And see, what ends up happening is, I just ran into this scenario the other day. A person will have a power of attorney over somebody, and then they'll start signing documents that benefit themselves.
Oh my God.
But the person that they're doing it for may have told them that that's okay. But the law says if you have a power of attorney for somebody, you cannot take from that person, because it's a presumption that it's undue influence. If you have a power of attorney over, it's presumed that you would have undue influence over that person, because they gave you control over them. So if you start taking their stuff using your power of attorney, that's that undue influence, and
Well,
courts will reverse that.
I actually see that. I see that differently. I see that as you doing what the person who gave you the power of attorney want it done.
You
And,
can-
and so because it says that there.
Yeah, you can see it any way you want
No,
to,
no,
but
it says that the person has the right to transfer stock, to sell real estate, to do everything that I would do
Yeah.
had I been able to do it.
yeah, but the presumption is if you do it to yourself or for your benefit, that you have undue influence over that person.
I can see the argument.
Yeah, and well, I mean, and it ain't me. That's the law. The law said it's presumed.
I don't see that.
No, that's the law. The law is it's a rebuttable presumption.
And you just said the right
Yeah,
thing.
yeah, it's a rebuttable presumption. But that's an uphill battle, though,
Not,
Ron.
not necessarily there.
Shoot.
Everything is a rebuttal presumption.
Yeah.
Because whatever we present to the court, it starts out being here. And so when the prosecutor comes up and do that thing, so the bar is raised to here. But when the defense comes along, the defense is able
Okay.
to come back and level it out and pass it.
Okay, so let's and we got.
Was that-
I know, no. Let me just show you how hard it is
Okay,
to overcome a rebuttable presumption
Okay.
on a quick claim deed that transfers a house to somebody, right? How do you rebut that presumption that you didn't have undue influence for? Because if you talk to your siblings and they have an issue with it, they're going to say, "See, Mama didn't want to do that."
Oh yeah, I see what you're saying. That, but if you transfer it to all of the siblings,
Then
because
there's-
I see what you're saying.
Yeah,
now.
if you transfer it to yourself,
Oh.
there's an issue.
Oh, I'm
but
agreeing
but
with
if you
you now.
transfer it to everybody, then now it's presumed that okay, this is probably what.
Oh,
my
I
mom-
agree.
Yeah,
because that's kind of what happened when my mom and dad were about to pass.
Mm-hmm.
They had already told me what they wanted done, and so that's what we did was based on what they had told us already. But you're right. I agree with you on that now.
yeah, because bank accounts, you start transferring
Oh, no,
money. Yeah,
oh, no.
It may be what the person wants.
Yeah.
but
Oh, I agree with that. now.
people are going to look at it in a negative way.
Certainly.
Yeah, and
Certainly.
so that's always the key. All right, well, I guess we about to. Yeah. I'm getting my wrap it up symbol.
But that was good, Daryl, because that's a good place to start. Because we always are concerned about the cost.
Yeah.
And so the easy and the most reasonable way to do it is with the holographic wheel.
Yeah, and that's just so ineffective. And we're gonna this probate series. We're gonna take it a couple more shows.
Okay.
And we may bring a couple people in there to mess with this a little
Okay.
bit more.
I like
so, thank you for watching the show. We'll see you back next week.